Welcome, everyone. Thank you for joining us. Hopefully, you're all staying inside and healthy. My name is Kelly Chan. I am the Community Relations and Public Service Manager here at CEB, a nonprofit program of the University of California. Today, we have two speakers. We have Mary Grace Guzman of Guzman Legal Solutions and Beth Mora of Mora Employment Law. They are both members of the California Women Lawyers Association, and they will be talking about employment and ethical impacts of COVID-19 and social distancing for your law practice. This is a content-packed presentation. We will send out the deck after today's webinar. If you have any questions, please chat them in. There is a chat icon at the bottom of your Zoom. There is also a Q&A icon, so you can do either. If we don't get to your question, again, because we have so much to go over today, Mary, Grace, and Beth have graciously offered to stay about 20 minutes after the presentation to do Q&A for those of you who can stay a little longer with us. If we don't get through your questions, we will take them down and we'll send you a written response via email after today's presentation. So just to start it off, I'm going to hand this over to Mary Grace, so you can kick us off.
Awesome. Hello, everyone. I hope you're all doing well. As you all know, I'm Mary Grace Guzman. I practice legal ethics. I represent lawyers, law students, and law firms. I advise them on their legal ethics issues, risk management, and state bar matters. Just bear with us. I'm going to be covering legal ethics, but a lot of what I'm presenting is actually going to be more on the risk management side of things, because really this is a quick moving process. Many of us are currently in shelter in place, others of us are not, and the courts are starting to figure this all out. Again, I cannot stress this is a best practices. There are ethics considerations, and the reason why we're going with a best practices model is that if you do your best to manage your law firm, ideally you'll also in the process be managing your legal ethics issues. Alrighty, so let's get started. I'm not going to be going into these rules in any detail, but these are the rules you should rely on, and court rule and business professions. And of course, if you see on the bottom, there's a state bar website that you can review that's giving us state bar advice on COVID and how they're managing it. These are rules that you should be considering when thinking about your legal practice. Again, it's quickly moving. And we put this together, and it is meant as a roadmap, not necessarily to cover all possibilities of what may happen to your law firm. Alrighty, so this here is actually a checklist, and it's meant to be a checklist. You all can review it on your own. Some of us are currently and unexpectedly ended up in a virtual space right now. Most of the Bay Area is now shut down, and we're all in shelter in place. And other counties are slowly moving into that direction. This here is a list of what you should be considering when moving to a remote practice. And this is a list of, and I apologize, I guess I'm having some internet connections. If you're going to keep your doors open for right now, and if you're able to, these are some of the considerations that you should be implementing while you're keeping your doors open. I highly encourage you to look at CDC with regard to guidelines for businesses when they are bringing in other individuals and cleanliness practices. All right, so let's get into the nuts and bolts of some of the issues. You're going to have clients who are going to be scared. And this is our big one that we're all going to be facing, is dealing with client issues. Most importantly, you need to manage your clients' expectations. That's absolute number one. You're going to have clients who are scared themselves. They're going to be frustrated, and you, first of all, don't take it personally. Secondly, if you have not already done so, organize and send out a letter to all of your clients, every single one of them, advising them of any anticipated delays, known or expected. And I give you some of the examples. Courts are now closing, so it could be postponement of court hearings, trials, depositions, For a big one would be disbursement of settlement checks, administrative hearings, mediations. Also, as you learn new information, you're going to want to update your clients about the new information, how it impacts their cases. With regard to depositions or anything where the client actually has to appear, you really want to consider a couple of things. One is your client is a part of the at-risk age group? Because you may want to either postpone, or if there's video available, you want to offer the video or telephonic appearances. For those who do not appear to be a part of an at-risk age group, you want to consider, do they have an autoimmune compromised issue? I'll use myself as an example. I don't appear like I have an autoimmune disease, but I do have a very rare autoimmune disease, and so I'm taking extra precautions. So you want to find that out. Most importantly, this is confidential information. You don't want to share it with opposing parties. Now, with regard to your offices, if you are still open and you're practicing some sort of modified version of your office hours, you want to include that in your emails and the signatures. You want to include with that advice that for people to expect delays. A reasonable delay is about 24 hours. When you're managing your phones, you want to forward your landlines to cell phones if you can, and also in your voicemail advise on any potential delays. If you are regularly litigating, and let's just assume you're in a particular, you only litigate in one county, you might want to give it information about the status of your courts. Again, this is, I think, a very good business practice consideration. It's anticipate your clients asking questions that does not impact their particular case. They may want to know community services. They may want to know other information that, because they see us as a source of information, they see us as experts, they see us as, we know stuff is really what it is. And so yeah, I'm not saying that you have to give this information to your clients, but I do believe it is good practices. Some practice areas that you may be in, immigration I think is a good example, family law is a very good example, where you receive from your clients a lot of questions that does not involve the actual practice that you're involved with. So just anticipate it. Make a decision whether you're going to share that information or not, and how you're going to share that information. And the most important piece here is communication is key to avoid frustrated clients. The number one way for a fee dispute to arise, for a state bar discipline investigation to come up, or even a malpractice, it usually starts with communication. If a client feels that they're not being heard, if the client feels that the attorney is not regularly communicating to them, then the client is going to feel that there's something wrong with the attorney, and then they're going to file a complaint, dispute fees, or look for reasons why you committed malpractice. Okay, next, and this is going to be a big one for malpractice issues. Stay on top of your calendar. There are now tolling deadlines that are currently happening. Unfortunately, it's not statewide. It is happening jurisdiction by jurisdiction. So you really want to stay on top of where your deadlines are, what the individual jurisdictions are actually doing. Where it is appropriate, I'm going to hold on while my internet catches up. Where it is appropriate, I highly encourage you to request for waivers, whether it's deadlines on discovery, interrogatories, depositions, anything that you can ask for waivers from your other opposing counsel, and just play nice with that, please. And then anticipate the snowball effect. Okay, we already know that their courts are starting to close. Each courthouse is doing a different practice. Some of them are still having active trials, others are not. So you really want to stay on top of this and also anticipate the snowball effect, and again, communicate that to your clients, especially those that it'll impact. Now we're going to talk about documents. Some of you are not electronic, others of you are electronic. If you are currently not electronic, you want to look at some sort of cloud-based or online service. And if you already have a management system, you probably are hooked up with Google Docs, there's Dropbox, so you want to use something like that to manage your documents. If you have to bring files home, especially if you are the partner and your associates or your paralegals are taking files home, you want to have a tracking system. Maybe you create a custody, an order of custody list, and have someone in the office be responsible for managing that information, so you know where the file is, so that, you know, 6 months from now, 2 months from now, whenever we're all back to normal, you know where the document went, you know where the file is, and it can be returned back to the office. Also, advise employees how you're intending to manage the files, okay? So we're now at home, we have other family members, there's confidential information, you want to have a protocol as how you expect that file to be handled. Next, electronic files that are not on the cloud. Some of us may not have a cloud-based system, but we have a large hard drive in the office, and other computers are hooked up to that, and there's no remote access. So you, again, similar, treat it as a paper file. How are you going to manage that? Who's going to take the electronic files home? How are you going to update the master file? If a client is dropping off physical files, have a protocol for that. It can be delivered to your home. Some of us are in practices where you don't want your clients to know where you live, so figure out a common meeting place. Could still be your office, it may not be. Also, I think the best thing though is to have clients deliver the documents electronically, impress upon them to preserve the actual documents because you don't want them destroyed, and then they'll be delivered to you at a later date. Keep in mind that you may not actually need the originals right now for review. You may only need the copies. All right, now we're going to get into court closures. This is changing day by day. The order was issued on March 16th, and the Supreme Court said that there can be closures, and it's going to be based on local health departments and state health departments. So it's been a bit of a free-for-all. Several counties, our county, Contra Costa is definitely included in this, are now closed, and they have certain rules with regard to what they're hearing at this exact moment. And so I highly recommend, and you'll see it right here, this article. There's a link to it, and it is being updated regularly, and it is free. So it has a list of all the county courthouses and what their status is and what they're capable of offering the community. Also, you're going to have to create a system to track all your court procedures for each jurisdiction. Many of you should already be doing that, but it's going to be different now because it's going to be changing very quickly. If you have a case management system, that should be easy enough, but again, it's something that you're going to have to keep track of, because Orange County is a really good example. They announced, I believe it was today, that they're going to have they're going to condense 3 days of appearances, and all of those appearances will be condensed into 1 day. So we'll see how that goes. Similarly with federal courts, tax court, USPTO, all of those are going to have closures. And so you want to pay attention to those jurisdictions to find out what their rules are and what they're doing. Some courts are now issuing new local rules, so you're going to have to pay attention to that information too. It is a lot. So I would encourage you all to, if you have employees, have someone potentially be assigned to that piece, and that's going to be their job. All right, now we're going to get into managing your IOLTA. If you're a remote, it may mean that you don't have access to the money that's coming into your firm because it's going to be going into your physical space. So what you're going to have to do is you're going to have to create a protocol regarding collecting mail, depositing checks, and identifying and notifying individuals about disbursements. So name someone who's going to do that. Ideally, if it is a law firm with a managing partner, I do believe it should be the managing partner who takes care of that. Also, when funds will be deposited, and if appropriate, when clients and third parties will be notified of the funds. If possible, use your mobile banking app. The problem is that many of these mobile banking apps have limits as to how much you can put into your accounts per day, per week, and per month. So you want to find that out also, and this is could potentially happen, it hasn't yet, but you should anticipate banks shutting down, and you should have a plan for that. As for disbursements, Rule 115D1 requires an attorney to promptly notify clients and third parties of the receipt of funds. Okay, so when you have the funds, it's triggered when the attorney has the funds, okay? For those of us who are in shelter in place, this is tricky because if the mail is still being sent to our offices, we're now in a gray area. It's being sent to our offices. Are we technically in receipt of funds? Yes, because it's in our offices. If you can, have your mail forwarded to your home address. That can fix the problem. Otherwise, you're going to have to figure out how often you're going to your offices and how often you're going to, collect that mail. If possible, request disbursements to be issued via wire transfer directly into trust. And again, advise clients of expected delays of these disbursements, because if they know the settlement is here and they know the check's coming to you at some time soon, they're going to be anxious for that money, especially given where their employment may or may not be at this time. All right, for mediation and arbitration, I've called ADR and JAMS, and they are handling mediation arbitration on a case-by-case basis. So you want to call your particular mediator and arbitrator for guidance. Beth called a private mediator and learned that they were engaging in mediation via video. So again, you want to find out how different organizations are handling the shelter in place, or how they're handling within their own community these types of face-to-face meetings. Now, this is really important. Cannot stress this enough. Right, we do have a duty of civility. It's now in the court rules. It's a part of our new oath. We also have a duty of fairness. And there is a rule, I put it in the rules list, that requires us to be fair to opposing parties. Now is not the time to be difficult. I cannot stress that enough. I don't think judges want to find out about that. Do not take advantage of the crisis to create any unnecessary delays or frustrations. If it's legally acceptable and it's within the legal issues that you're currently dealing with, for example, privilege or confidential information that you feel the opposing party should not have access to, that's perfectly fine. But if it's something that opposing parties should have access to, just try not to be difficult. Also, and that also goes with regard to being fair in offering delays and being reasonable in that way. Also, throughout this whole process, ask yourself, if I do X, is it going to help or hurt my client's interests? Because that really is what happens when we're dealing with these kinds of interpersonal relationships with opposing counsel. Now, you need to plan and have a contingency plan. This really hit home this week for me. I had an intake where a non-attorney called me asking how to manage their partner, as in relationship, who had passed away. And it was pretty hard to hear. And so I'm currently actually working on creating some content on that particular issue, but this is what I've come up with thus far. So it's hard to talk about that piece, but we're gonna focus on if we get sick. And this should be true for any of us. I have an autoimmune disease, I get anaphylaxis, so I need to plan for sick days when I literally cannot work. So first, partner with another counsel. This is especially important for those of you who are solos, okay? Then you want to have case summaries, because if someone has to step in your place and you don't have a case summary or your case isn't well put together, they're gonna have a difficult time figuring out what to do next. Create a plan on how you will communicate should you have exposure or come down with it, who you're going to communicate that to, your clients, third parties, other individuals. I don't think this is an ethics issue. I don't know exactly how CDC is advising those who have been infected in terms of how they're telling other people. But we all are learning of attorneys who've come down with it and exposed other people. We are learning about this from, the news on almost a daily basis. So you want to find out and make that plan. Finally, the last two is, with regard to your business, have a list of all your bank account numbers, your passwords, your subscriptions, your memberships, and then give that information to a family member so that they have that information. Let them know where it is. And then finally, update your billables. I know that's everyone's favorite topic, but keep your billables and your accounting up to date, because it's going to be easier for someone to step in your place should you either be too ill or the unfortunate passing of you. Okay, I am done. I tried to do that in 30 minutes. I have 7 minutes left. So Beth, are you ready?
You have a question.
Okay, what's my question? I don't see it. Okay.
Oh, I can read it one for you. One of the questions is, I do estate planning. I want to offer remote estate planning where I never meet the clients in person, but instead do everything over the phone. How do I do this ethically and protect against lack of capacity and undue influence?
I'm going to be honest with you. I would rather get back to you on that. I know that one thing you can definitely do is incorporate video. So Zoom is offering, you can definitely become a member of Zoom, and it's free. You can do a video conference. I know that's difficult though, because not everybody has access to technology. If it is phone and you can't determine the capacity issue, I would rather get back to you on that piece, because I just honestly don't know.
And we have another, they're really looking for your input on this. So I'm just going to read the question.
Okay.
I have a mediation coming up April 1st, but waiting for a court order to be signed, which requires an event has to happen at least 30 days before the mediation. Opposing counsel takes the position that the mediation has to go forward. Are people doing mediations or canceling? I don't think the mediation should be happening even without the outstanding discovery order. Any input is appreciated.
When is and it's in Alameda, which is still in shelter in place. So I think the question would be whether or not this issue falls within the essential services. I would start there. Shelter in place is supposed to end potentially April 7th, but it's definitely an indefinite. It could be indefinite. I would push back on this to try and cancel it. I don't think it's unreasonable to cancel these things. Like I said, we're all flying by the seat of our pants on this. But I do think that if April 1st is within the shelter in place, and if this mediation is a non-essential mediation, meaning that doesn't fall within the guidelines of that particular county, then you might be able to get it shut down that way. As for the 30 days, that's a tough question. I would feel more comfortable answering that with more research.
Okay. Good afternoon, everyone. Thank you for hanging out with us. I hope you're enjoying your remote working and your shelter in place working or your unique situations. This is COVID-19 and employment law. We're going to just talk a little bit about how this might affect you as employers, solos, small law firms, for you as employers, for you and your employees, and also for employment law advice you might give other people. So it's an overlap in giving you basic foundation information and a significant amount of links and other data to use. Again, it's a lot of changing information as well. So please do look into the links to get the different information that applies to you. First, we're going to focus on wage loss replacement options and compensation for you, your employees, and the people who will ask you questions. Obviously, the first and foremost would be employer-provided compensation, either employers who can voluntarily provide compensation or earned and unused compensation depending on the employer's policies, and available compensation such as vacation, sick, which we'll talk about more below, or available paid time off. So obviously look at available policies and procedures, pay stubs to see what you have, and accruals. The most common defaulted to when there's a loss of a job, a layoff, or a reduction in hours is unemployment. So you can have wage loss and replacement through a layoff, reduction of full or part-time wage replacement up to 26 weeks, and it can be equivalent of $40 or $450 a week. Through the governor's executive order, he's waived the 1-week delay. Obviously, there is a considerable amount of people applying, so the system online is crashing and freezing. So the sooner people can get on and apply, the better. A lot of small law firms and solos with the support staff are asking their staff to apply for reduced hour compensation and even layoff compensation. It's understandable. And there are links here for the coronavirus resources and FAQs and employer information, and the work-share program, reduced hours, is the most common looked at right now by small law firms. For example, if their staff is working 10 hours a week, they want them to apply for the differential. State disability insurance, or SDI, is when someone is unable to work due to a medical quarantine or illness related to COVID-19. Obviously, it's for other reasons. We're focusing here just on COVID-19. This is a non-work-related injury. This is different. This is for COVID-19 and medical quarantine, certified by a doctor for full or part-time employee, full or partial wage loss up to 52 weeks. Would be approximately 60 to 70% of compensation of $50 up to $1,300 a week, and it's tax exempt. Again, the link is here for people to apply, find out a little bit more about qualifications. There's paid family leave when someone's unable to work when they're caring for an ill or quarantined family member. Certified by a medical professional, up to 6 weeks of benefits, a full or partial loss of wages, approximately 60 to 70% of compensation, $50 to $1,300 a week. And there's the links there as well of what makes you eligible, as well as how to file a claim. Wage loss and replacement also is paid sick leave. We know that's an area that became kind of confusing and complex, but there's 3 days of paid sick leave in California. I'm going to reduce this down here. For employees, that they can be used if you are a family member or used if you or a family member are sick or for preventative care when civil authorities recommend a quarantine, paid at your regular rate of pay based on your average of last 90 days. Several cities in California have additional sick leave policies providing for up to 6 or even 9 days of sick leave. So make sure that you're looking at the city in which you are in. Berkeley, Emeryville, Los Angeles, Oakland, San Diego, San Francisco, and Santa Monica have higher sick leave policy availability. So down below is a very detailed information about sick leave, and it's been updated. Okay. One of the things to keep in mind is that AB 5, one of the new legislations that came into effect in this year, saying that employees have been misclassified and that as independent contractors. If we have someone who's been misclassified and they are actually an employee, these benefits are something that they should be getting. That can apply to you, that can apply to your employees, that can apply to people who come to you for information. So these are benefits they should be getting. They have a right to apply for them. So there's several things here to please keep in mind. If someone applies for them and they were misclassified, that is something the state can determine. And so it's very important that you as an employer evaluate whether or not someone was misclassified. So there's links here for you to do that analysis. You can also talk to a qualified employer attorney to make sure you've done this analysis correctly, as well as employees who think they've been misclassified can walk through this analysis and apply for benefits. Obviously, there's other benefits that may come through an employer. For example, you may have a private benefits like short-term disability, long-term disability through an employer's benefit plan. There could be supplemental disability benefits or family disability benefits through an employer offered plan. One of the best ways to see if you have that, if you don't recall, is looking at your pay stub. See if there was a benefit amount taken out of your pay or contributed on your behalf, looking at the handbook to see what benefits you have or summary of your benefits provided by the employer. Some people have a private disability plans that they've purchased on their own separate from the employer. You want to look at these plans and get what's called a summary plan document. See if you qualify for that benefit should you become ill. You don't want to pass up that opportunity. These are some additional benefits and information about benefits for you to look at for yourself, for businesses, for your employees, give you some guidance and resources about wage replacement and loss of compensation. Is there questions on this before I move forward? There's a wonderful chart here that is actually not as easy to read here, but in your handout you'll receive it's much easier, and this link that will walk you through disability insurance, paid family leave, unemployment, paid sick leave, workers' compensation, and links to each one.
We actually have two questions. I don't know if you can see it, Beth, but
no,
I cannot.
I'll read them to you, Beth. So the first one is if an attorney is self-employed, are they eligible for state disability should they come down with COVID-19? They do not have any other insurance benefits.
State disability, it depends on how they paid themselves. So they should hit these links. That's a great question. I'm sorry to hear that they're asking that question, but they should hit these links. That's why I provided them so they can walk through the analysis. It's plausible that they would be, and they should look at to make sure that they've qualify. So yes, they should look at that.
Okay, and then
oh, there's the Q&A. Sorry.
You found it?
Yeah, okay. Since we are now asking employees to work from home, do we need to comply with their home city's requirements on sick leave as opposed to their usual location? Oh, that's fantastic. So that's a great question. So if you are, let's say, in a county that is not have a special requirement, but they live in Oakland, I do not think that's true. I do not know, though. That's a fantastic question. I will look that up. Who's asking me that? Anonymous attendee, darn. Okay, so I will have to look that up. That's a question I don't know. I think it's based on the workplace, but if they are working from home and it's an extended period of time, and it actually, well, obviously if it became a permanent location and this became a new thing, then I think it would become a problem. And yes, you would have to comply with the new location requirements. But if it's just a temporary thing, for example, then no. But I would like to look that up. It's not a question I've ever heard, and I think it's a fantastic question. For unemployment benefits, can we have staff continue to work partial hours? Yes, that's the whole point of that work share concept and the reduction in hours. If someone, let's say, works 10 hours or 15 hours, but they can then apply for the differential, the loss of income. Obviously, it's not likely to be the same amount of what they were making, but they are going to get some made up lost time. Oh, how does the paid sick leave House bill affect this? Affect what? The state have not had a chance to look at the federal paid sick leave. I understand it is 2 weeks of paid sick leave for employers and employees that it qualifies that qualify for it. I did not see the qualifying standards. I was trying to look at it this morning. I believe it's for a significant number of employees for a larger size employer, but I do not know. I did not get a chance to look at it, so I apologize. This is a general comment. Folks should also be aware, which protects employees from retaliation, for making complaints of unsafe workplaces for their employer. Okay, that's a good point, Rebecca, yes. So we are going to get to some of that, but yes, you cannot retaliate against someone for making a complaint of an unsafe work environment. Thank you. Okay, so please look at this. Yeah.
We actually have another question that came in through the chat.
Okay.
2 questions. I'm just going to read it off. This is a question from an estate planner subject to the shelter-in-place order. So the first question is, what are the definition or scope of legally mandated legal services? I can easily handle 95% plus of my services remotely, but there are certain situations where face-to-face meetings may be necessary. May I legally venture out?
You know, I am going to pull up, as I think one, it really starts with what jurisdiction is she in, what county is she in, because like Beth and I were trying to figure out whether or not we fell into an exempted group so that we could be in the same room doing the presentation. And when we looked at the Contra Costa order for shelter in place, we couldn't figure out the exception. We felt that we didn't fall into that exception. So really, I think it's going to start with reading the order from your county. They're relatively broad. I do think legal services can potentially fall into that, you know, essential services, in the sense that there are going to be times where there is a true emergency. If we're talking about TROs, individual safety. I think if in the situations of estate planners where they really do need a signature and you believe that the person is in the process of dying, then I think it's realistic to leave your space and meet them face to face. It will be a case-by-case basis. We really are not going to know how our governments are going to treat us until it actually happens. I mean, that's literally what we're dealing with at this point. And things are changing day by day. Governor Newsom had just announced that we may be subject to martial law. I don't share that to scare you, but I share that with you because these are the considerations that we all need to be thinking about. As for differentiating between clients who are in different stages in their health, you know, someone who's closer to death than others, State Bar does have a rule with regard to not discriminating against clients. In this situation, I think it's a judgment call because you're trying to help the client based on their legal needs and their health needs. So I don't see that as a problem.
Okay, I just wanted to answer the Families First Coronavirus Response Act. Emergency paid sick leave requires that all businesses with less than 500 employees provide 10 days or 80 hours of paid sick time to any full-time employee. And it's got an element for part-time, not able to work for one of the following 6 reasons, and it details reasons relating to quarantine, by symptoms, doctor ordered, medical diagnosis, minor child with illness, and so forth. It implies immediately upon hire to all employees, even if employees only worked 1 day, and expires December 31st, 2020. And an employer's obligation to provide pay sick leave is limited to $511 per day to a total of $5,110.
Another question, Beth?
That was the question someone asked me earlier.
Okay, and then there's another question. If an attorney is trying to preserve their employees' positions within the firm, but maintain their finances, can they reduce their employees' pay to minimum wage or hourly if they were salaried? And, you know, basically, can they be creative in how they are able to maintain their employees and giving them pay? And is that a problem?
Okay, well, there's two answers. One, as we just discussed, you can reduce hours and they can apply for a reduced hour differential with EDD. You can always ask an employee if they would like to negotiate a reduced compensation, unless there's a contract negotiating something different, and ensuring that you don't do it based on any discriminatory bias, like, for example, only offering it to women or people of the same race and different race and national origin, or based on a disability. But you can ask employees if they would like to negotiate a reduced compensation to maintain employment. And I would suggest that you agree that it's for a limited period of time and so forth. I think shifting from salary to hourly rate could be problematic, depending whether or not someone should or shouldn't be exempt. And that should be very carefully analyzed based on the position, and maybe with the help with a trained employment attorney.
And then there's another question, but I think it's going to be discussed further down in your presentation, which is workers' benefits spreadsheet with regard to the new bill. So does workers' benefits spreadsheet include the new bill passed? Or
no, this is a state spreadsheet, a spreadsheet the state provided. No, I don't have a new federal spreadsheet. It just was passed last night. Sorry. Okay, I'm going to move into leave rights and leave protections. That was compensation, and obviously it's an overview. There is all sorts of different compensation options. Those are just the main primary areas that you can look at. Here, when you have issues with COVID-19, we're not talking about all potential leave issues. We're focusing on COVID-19 and potential leave issues. If you are not in a shelter in place and the workplace did not already order a closing of the workplace, employees may approach the employer and ask for an accommodation, for example, of telecommuting. You could have a situation where an employee says to the employer, I would like a reasonable accommodation to telecommute. They can ask for that. They can say it's due to a disability. They ask for reasonable accommodation. They probably medically certified. That would fall under the Fair Employment and Housing Act that requires an employer has 5 or more employees. Why an employer has to be careful and pay attention is that if they can ask for that accommodation if they have, for example, immune compromise, pre-existing condition. An employer has to ensure that they are engaging in the interactive process. They are providing a reasonable accommodation if it's appropriate and can be done. It's a very high standard to say, no, we can't provide that reasonable accommodation. They have to show it's the undue hardship. If they can't provide a telecommuting accommodation, and they can show a good cause of why they couldn't, a reasonable accommodation may be leave. So there are leave rights and leave protections, and that could be a reasonable accommodation that someone may ask for. California Family Rights Act could provide leave protections for someone if they are seeking a medical leave for their own serious health condition or the care for a family member's serious health condition. Again, that may be medically certified. To be fair, in this urgent time, it may be very difficult for someone to get a medical certification right away. So you could see situations where people are asking for a serious accommodation, a serious health condition, medical leave accommodation, but the certification comes later. This is a job protected leave. Unpaid, it can be unpaid. It just depends on what options there are. It could be a maximum of 12 weeks. It's a continuation of health benefits during that time, but it applies to an employee who's worked at an employer for 1 year 1,250 plus hours in that year, and the employer that has at least 50 employees in a 75-mile radius. Though that leave is often unpaid, depending on the work situation and the policies, they can apply for short-term state disability and also look at any private policies the employer might have. You cannot retaliate against an employee for seeking these leave protections. And that would include using the sick leave that we have talked about, applying for workers' compensation, because you can apply for workers' compensation if you've been injured on the job through COVID-19. Let's say you're a nurse or a doctor and you obtained COVID-19 on the job, you could apply for workers' comp. You cannot retaliate against someone for that. You cannot retaliate against someone for seeking a reasonable accommodation due to a disability that arose from COVID-19 under FEHA, for seeking a CIFRA leave just for their serious health condition, or even using kin care, which I've given you the link for, using that time for family. There's a real developing dilemma here, which is what's coming out, and it's complex for small firms, firms of all sizes, is that balancing the duty between the employer's desire and responsibility to create a safe working environment with the rights of employees. And so what we all know that under the California Fair Employment Housing Act, it is illegal for an employer to fire, fail to hire, or engage in discrimination, harassment, or retaliation in any way against their employees because of multiple protected classifications. But here we're going to focus on disability, race, national origin, or association with any of those classes. At the same time, the employer is permitted to ask an employee to seek medical attention and get tested for COVID-19. And that the CDC states that the employees who exhibit symptoms of influenza-like illnesses at work during a pandemic should leave the workplace. How does this balance out? Because that COVID-19 was classified as a pandemic with growing anxieties, it is incumbent upon employers to be vigilant in our workplaces to avoid discrimination, harassment, and retaliation. We are already seeing stories of discrimination, harassment, and retaliation. Let's see how this plays out. National origin. An employer cannot treat their employees in any different fashion because of real or perceived bias against race, national origin, or negative stereotypes. It is hard. This is times where people are scary. I understand, but you still cannot use those real or perceived biases against national origin. Employees cannot refuse to sit next to someone because they are of Asian descent. Employers cannot only ask an employee of a Chinese national origin to work remotely. An employer cannot ask someone who's Italian if they have COVID-19 and no one else. These are examples of things that are developing. They're out of fear, but fear does not justify discrimination. Is there a question? Did I see?
There's some questions.
Okay. Are they about I can't.
Yeah, so, well, one of them, hello. So one of the questions is specifically just advising that that at least in San Francisco, there is an exception for legal services necessary to assist compliance with legally mandated activities. I think from an ethics perspective, you'd really want to find out what legally mandated activities means. Court appearances definitely would fall into that category. Meeting with the client to sign documents. We can use electronic, there's DocuSign that is now being accepted by the rules of professional responsibility. There are other ways, I forget the rule off the top of my head, but there is a way at least to get engagement letters signed without necessarily having a wet signature and being in front of each other. There's a second question, which is, if a California employer already provides sick leave, is the emergency federal sick leave concurrent with California law requirements or on top of what is already provided?
I'm sorry, say that again?
So if the California employer already provides sick leave, so they've already given this to them, now we have the emergency federal sick leave, which is it concurrent with California law requirements, or is this on top of? So if someone gives them 2 weeks already, and now we have the federal rule, does the federal rule give them now 4 weeks of sick leave? I think that's what they're asking.
I think that's what they're asking. I do not believe it adds on to. I have not had a chance to read the federal in great length, but I do not believe it's an add-on.
Okay, then the second one is, if a company has a policy regarding benefits for only those working 30 hours or more, how might the hours reduction be adverse? Could it come to pass that insurance companies terminate medical benefits?
Oh, that's a great question. So in those policy documents, it will say at what juncture policies benefits may terminate. But you're seeing that most employers are putting a stay on that, just like you're seeing a stay on evictions or things like that. It is important to check with the employer about that. Worst case scenario, you will get a COBRA notice, but it's highly unlikely that you're going to see a lot of that anytime soon. But I do think down the line, we will see more and more employers that will initiate that when they can't afford to carry the benefits anymore. It won't be out of utter cruelness, though we might see that. It will be out of the fact that they no longer have monies or aren't staying in business, such as small businesses.
Okay. I wanted to circle back to something that because we have so much content, I kind of jumped over a little bit. We have a duty of competency. It is Rule 1.1. I encourage you all to read it, because that rule specifically includes language that refers to our legal services. We must deliver our legal services in a competent way. This rule is not only dealing with it. Yes, it encompasses what we all know is competency, which is alcohol, drugs, and other issues such as that. But this rule is actually looking at how we practice law. And so when you think about our rules of professional responsibility, we really should be thinking about how do we do things. And within competency, I truly believe that an important piece is taking care of yourself. And if you are feeling overwhelmed, there are lots of solo attorneys who may be looking for work. You may not want to hand them a complex project, but you may need that additional assistance. So please consider, how are you going to maintain your competency when we are balancing everything? I'm a single parent. I have a solo practice. I have a child who's at home. I have my parents who are in their 70s. Some of us are now officially in the sandwich generation, so we're managing a lot of different moving parts. And so I highly encourage you. That's why I wrote partner with other attorneys, because you really need to think about how you can provide the best services while managing our personal lives in the process and our own stresses.
From here, we're also talking about one of the things that's really important, even though employers do have a duty to provide a workplace that's safe and healthy for their employees. In doing that and in gathering information and data, they also have to ensure that they do not target their employees based on real and perceived disability, and that they don't violate their privacy. So an employer isn't to make an assumption about illness or health condition and assuming that someone has the virus. But an employer cannot actually ask someone, do you have an immune compromised condition, or if you have the actual virus. It is important that they do comply with anti-discrimination laws while they're seeking guidance from the CDC. Now that can be very confusing, so I try to give you some examples. How much information may an employer request from an employee who calls in sick in order to protect the rest of its workforce during COVID-19? So you may ask an employee if they're experiencing symptoms of the virus, such as fever, chills, coughing, shortness of breath. And then you have to maintain the information you obtain from the employee in that process confidential. You cannot say, do you have an immune compromised condition that might make you more susceptible? and for more detailed information, that's a violation of privacy. Traditionally, employers would not be able to, for example, give employees like a temperature test. Now, since we are in a qualified pandemic, you can actually do that, but still you do have to keep these things confidential. This is a unique, different time. You have to be careful about what you ask and how you ask it, but regardless, you have to keep it confidential. I've given you links here to guidelines and sample answers by the EEOC of how specifically to handle a pandemic and specifically the current coronavirus, how to walk through that while honoring people's disability and privacy. Did I see questions pop up?
One of the questions we had asked, we had already answered already. There's another one that says that letting you know they just tried DFEHCA.gov, and it appears it is possible to file the complaint online or get a right to sue.
Yes, of course. Okay, so one of the other things that's important is that in this time, when there are fears, it doesn't justify discriminating against someone because of their association with a protected class. One of the more common you will see is if it is believed that someone is associated with another who has coronavirus, or a family member might have it, or associated with someone from a protected class. Earlier on, we were seeing someone who was of, for example, Chinese national origin. Oh, well, then they must be sick, or I can't be around them. Employers cannot make assumptions about someone who's associated with another. Along these lines, it's also important to remember that we have to have privacy. You have to keep people's information private. There may be data that is collected that you are allowed to collect, but it still has to be kept private. I saw an article come across last week where a secretary at a law firm in Seattle died a day or two after she left work, not feeling well from coronavirus. And I was shocked that her name was out there. But obviously we know that information shares through social media and emails and what have you, but that was a violation of privacy. It wasn't California law, but it was still a violation of privacy. So it is really important that as much as we want to protect our employees and keep things safe and healthy, that you are still honoring and respecting their rights in the workplace. There are a few informational guides I've put here for employers. Legal Aid at Work has a wonderful handout that they've updated. A great Q&A, easy to follow for some complex issues, as well as the Department of Labor, OSHA, has given guidance on preparing workplaces for COVID-19. This is actually really detailed steps of how to create a safe working space, what you should and shouldn't do, and then guidance and preparedness plan for responses to diseases. I would suggest the #1 resource to look at, though, is the EEOC ADA guidance on pandemic and COVID-19. The most difficult thing I'm seeing for employers is how to ask the right questions about safety around disability without violating people's privacy. It is a really hard area right now. Even the most well-intended people are making violations. Any questions? No?
No, I'm not seeing any questions coming in.
Okay, no problem.
Okay, well, thank you all.
Yeah, we will send out the PowerPoint deck shortly, and it'll include Beth's information as well as Mary Grace's information.
Oh wait, there's a question that just popped up. Oh, no, that wasn't a question, it was just a thank you. Never mind.
Thanks, Margie.
Thank you, everyone, and take care. Be safe.
Thank you, everyone.